Okay, so we're going to start. So I'm pleased to wish everyone welcome to this roundtable on legal strategies in democratic backsliding and resistance in Africa. So my name is Vibeke Wang. I'm a senior researcher at Christian Michelsen Institute. And I've been tasked with moderating this roundtable, which I'm very excited to announce marks the publication of not only one book, but two books, both of which explore the use of law and courts for autocratic purposes in Africa. So the book titled Democratic Backsliding in Africa is edited by Leo Arriola, Lise Rakner, and Nick van der Wal, and is forthcoming at Oxford University Press this fall. So one of the editors, Lise Rakner, is with us here today. Lise is professor at the Department of Government at the University of Bergen and has led the research project Breaking Bad, Backlash Against Democracy in Africa. And the book is an output on this project. So several of the contributors to the book participate in this roundtable. And this includes Kendra Dupuy, who is a senior research fellow at Fridtjof Nansen Institute in Oslo. Matthew Jihohi, who holds a postdoctoral research position at CMI. And Fiona Shen Bayh, who is a postdoctoral researcher at College of William and Mary in the US. Fiona is also impressively the author of the book titled Undue Process, which is forthcoming with Cambridge University Press in September. So we'll learn more about both books in a few minutes. First, however, I'd also like to introduce our two remaining roundtable participants. Both can contribute with knowledge about the use and misuse of the law and courts in contexts outside Africa. First, Anastasia Leschussin. I'm sorry for my terrible mispronunciation, but Anastasia is a PhD candidate at McGill University in Canada. So her PhD research focuses on the Ukrainian judiciary and the impact of initiatives to strengthen judicial integrity and ethics on normative change. Andres Scharreger is a postdoctoral researcher based at the National University of San Martin in Argentina. His most recent work focuses on the impact of judicialization and how it has become a problem in and of itself. So many thanks to everyone for joining us. We'll start with the two book presentations, and these will be followed by a conversation about the book findings, and we'll end by opening with Q&A. Okay, so Lisa, the floor is yours. Yes, and then we'll move on to Fiona.
Do I need to press this to get the PowerPoint on? Okay, bare trykke den grønne, eller? Oh, it happened all by itself. Yeah, that I know. So thank you very much. I'm here to talk about the end of a relatively long journey, made 1 year at least longer because of COVID. And it's a book project that is sort of the end product and accumulation of lots of different research that has happened within our research group and the research project called Breaking Bad, or Backlash Against Democracy, since I think we started back in 2017. It feels bad. Anyway, this is what I'm going to present. So we hope this is a cover. It's made by Calvin Kaesa, right? Is that, yeah, who works in, he's part of a non-binary art collective in Nairobi, and we're super happy with it. Not 100% sure that OUP has bought into it exactly like that, but it will be something like that. That's where we are at this point, and we're super proud of it. I'm going to talk a little bit about the project and then the book, and here we are. So let me start by talking about the Breaking Bad project. There's a reason why we put up the former guy there. The reason is 2016. I agree with everything that Michael McCann and the former panel and just about everyone says. This is not the beginning of the erosion of democracy. Donald Trump was, he's a symptom. But something happened in 2016. Something happened that I think has become worse than we all imagined, and it would have longer consequences. And that is something we will talk more about. But for us, this became the start of, okay, this is really going on. Democracy is under attack. Liberal democracy is under attack. Why is that? And what are the elements of democracy that are actually challenged? And how are these attacks on democracy challenged? We did this. Oh, is it working? Because it doesn't. I don't hear myself the way I did. anyway, so we did this in the context of Africa, which is which is our specialty and our research group's specialty. And we are a huge group, I should say. This is where we started. To what extent does this actually travel? For those of you interested, we have a web page for the Breaking Bad project, and the project has produced a number of great articles. And I have to say, it's been exciting, and it's an incredibly productive group. You will hear more about it, but this is our start. So we know starting point. Yes, we know globally democracy in 2016, and in fact, every year since 2010 has been in decline. Put it easily with using global data, it's sort of a gravitation to the middle. There is a sort of gravitation towards a sort of hybridity and a kind of a gray zone, because very few regimes move straight back to dictatorship, and there are increasingly fewer actual liberal democracies. So there's a gravitation towards the middle. This we knew. We also had we have a clear idea that the democratic backsliding that we're witnessing is happening by democratic means. So these are democratically elected leaders who, with a majority in parliament or support in large groups of society, is chipping away on democracy. So this is sort of democratic erosion with democratic means. And as we heard about in the first panel, I have to click harder, this slow erosion of democracy, or the chipping away of bits and pieces of democracy, is happening through legal institutions. So this is all kind of relatively well known, but also very little is studied empirically and with sort of deep empirical data for one of the newest regions to democracy, namely sub-Saharan Africa, or Africa more generally, because this was a region where democracy sort of was reintroduced in the early 1990s. So while I'm sort of talking about what we knew kind of on a global scale, now I'm going to talk to you about what we learned taking this perspective to Africa. First of all, the data, the sort of aggregated global data on democratic backsliding, whether you use Polity, whether you use Freedom House, whether you use VDEM, it's not like it's showing very, very distinct trends. And especially for sub-Saharan Africa, it's more of a flat line. Looking at this, looking at rights, freedom of association, freedom to speak, freedom to participate, and looking at it in the next slide, I'm going to show you sort of sub-Saharan Africa as a total, and also the 6 country cases for our project. you will actually see something more looking like a flat line. You know, what do you do with flat lines? Well, maybe the first thing you do is to make sure that you're correct. So you recode and you look at different data and so in our book, there in the appendix, I don't think there is sort of a democratic indice that we're not citing and showing. So flat lines is kind of story, which led us to the starting point of our investigations. Because flat lines or status quo politics does not mean that nothing is going on. And this is what our work will show you. So basically, then, the finding is that the Africa democratic trajectory over the past two decades does, at a sort of global aggregated level, reflect status quo politics. There is neither substantial progress nor a substantial regression, for the continent as a whole in advancing political and civil liberties since the 1990 transitions. Now, this seeming stagnation of a sort of African democratization belies ongoing efforts by incumbents to actively undermine democratic actors and real democratization demands for democracy that has been going on. Because for the last 20 years in sub-Saharan Africa, we do see there's been an enormous increase in urbanization, economic growth, higher levels of education, and much higher levels of digitalization, all of which democratic theory presupposes more democracy. So basically, it is the demands for more democracy that has been suppressed by autocratic leaders. And this sort of balancing off by demands for democracy and relatively savvy autocratic leaders is what has led to this status quo. So in our book, the main argument is that the incumbent leaders have sought to contain democratic pressures through two interactive and sort of related processes: the use of legal institutions and the active use of international relationships. So bear in mind now, we are combining a kind of a classic sort of political economy, international relations story with a legal autocratization story. That is, in and of itself, it makes a lot of sense to us, and we hope it makes a lot of sense to this audience. But it's actually kind of new. That's actually two literatures that haven't really spoken to each other. So let's say, in search of this is the thing. There is no space in this day and time for incumbent leaders to be sort of without the sort of realm of the law. So the law and constitutional law is used very specifically for maintaining power. And this is very, very explicit, how all the sort of anti-democratic, autocratic processes are advocated for and explained within the realm of constitutional law. So legal instruments is one of the key, key mechanisms for autocratic leaders to maintain power. However, and this makes it complicated, and we will talk more about that, this is also the main instrument for the opposition. Using the law to claim democratic and civil liberties is also one of the main avenues for the opposition, which is something that our book sort of carefully tries to portray. This sort of how this mechanism is sort of the best friend of the opposition and the autocrat. So the second search for legitimacy for your autocratic rule is the use of your international instruments, and it's really to use claims of sovereignty to kind of control and maintain and keep down democratic pressures coming from civil society and opposition, and also from international donors and international NGOs. So this is a very interesting pact. And tomorrow we will actually talk much more about this, how this liberal democratic order, we can talk so much about the loopholes and all the not great things about it, we will. But it's also a clear fact that it has lost its power and its ability to put, to actually put forward a democratic agenda. And this is also through a really quite savvy use by autocratic leaders of sovereignty claims against liberal democratic demands from international partners. As we have walked along these years of our progress, the progress in our research, I think we've come to realize that we are more comfortable with using the term autocracy and autocratization processes more than sort of erosion of democracy or democratic backsliding. Why is that? That is because these processes, the use of legal means, the use of sovereignty claims, the gradual chipping away of rights, and all this happening within established institutions, it happens everywhere. It happens in autocracies as well as democracies. So these are sort of global processes, and we shouldn't just talk about democracies backsliding. This is a process for all. I'm going to put up a quote that I'm just going to leave it there. I'm not going to, so you can read it. I think it really sums up the panel we had this morning and Michael McCann's talk, and it's really sums up our work. See, these are it's all within the sort of realm of of legality and what can be seen as legitimate politics. So it's really not about breaking the law, but bending the law. It's about staying within this realm of what we call constitutionalism, call rule of law, what have you. And I think this is where, and this makes it so complicated to study it, because when is the system broken? When is democracy gone? When do we go out in the streets? Is it when the Polish, when the forced retirement age moves from 70 to 65? It's not something that really gets the people out in the streets. The problem, when this happens so slowly, this is why it's so difficult to protest. So, more as a kind of a cursor and a sort of promotion for tomorrow, what's next? Well, we don't give up, do we? So we've been lucky, we worked really hard for it, I would say. We have a new project, and we are moving from Breaking Bad into our next research endeavor, which is really looking at, it's called Rights Act, or Rights Activism Under Political Uncertainty. This project started actually this last week. We had our first project meeting. We will talk about more tomorrow. But this is where we start. These liberal democratic laws, the sort of unipolar world that was sort of put across in the early 2000s, is now severely challenged. What happens to human rights activists on the ground? Where do they go? Where do they go when the agenda that they've been working for, the organizations that's paying their work, are no longer seen as relevant or even legal? So in this next project, we look at the human rights activists. Final slide, and is just a reminder of why we're here. While I still think we need to talk about autocratization, I think we need to remind ourselves, with all this sort of whataboutism and this is not relevant, democracy is gone, and all our, kind of pessimism, which is hard to avoid, we need to remember why this is important. Because when universal values and international law are cast aside, then global affairs will be governed by force. And it's our job as researchers and as citizens to fight this. And democracy requires optimism because it's messy, it's not perfect, and we need to be optimists. I hope some of these findings are conveyed in our book, and I'm really looking forward to my colleagues presenting their work. And thank you.
Okay, so I'm Fiona Shen Bayh. I'm one of the project members of Breaking Bad and also Right Act, and I have been generously given the opportunity today to present my book, which is stemming from my dissertation project, which dovetailed a lot with a lot of the themes that we covered in Breaking Bad. So the book is titled Undue Process, Persecution and Punishment in Autocratic Courts. And part of what motivated this project were a couple of different questions. And so one thing I always found really interesting was the way that autocrats sort of perform their power, specifically looking at the criminalization of the opposition, but also these theatrical political trials. But especially a lot of these political trials where we take for granted what the outcomes are going to be from the start. So the main motivating question was, why are autocrats bothering with the fanfare of a judicial process, right, a politicized trial, when we already have an assumption of how these processes are going to end? So why do you actually bother going through these motions if we all know how it's going to end up? More broadly, what role do courts actually play in strategies of repression? So this is, a lot of political scientists are guilty of this. When we think about repression and political violence, we tend to think about extrajudicial processes, not judicial ones. So part of what I was trying to do with this book is sort of center narratives about political repression in the judicial sphere. And then finally, again, big picture question, what are the disciplinary dimensions of autocracy? And how is discipline itself institutionalized in different autocratic regimes? So just to give you, to situate this in the real world, not just the academic debates, a lot of the recent headlines that we see around the world when we talk about political prosecutions, it tends to frame persecution as prosecution. And this is actually a phrase that comes from the human rights community. I think I saw a lot of Amnesty International reports using this phrase. But yeah, a lot of the images that we have of these political processes suggest that, maybe something new is happening, right? This is a new phenomenon that has to be revisited, and maybe this is a puzzle that scholars should take up. But, and this is a theme which is coming up in a lot of these panels today, this isn't a new phenomenon. Right, autocratic legalism has a long-standing precedent in history, and so this is just some descriptive statistics from the Varieties of Democracy Institute looking at the degree to which autocratic regimes around the world were invoking rational legal ideals to justify their rule. And so if we look at the timeline, a lot of these trends actually started right in the mid-20th century. These are not new phenomena. So again, the questions of the book are threefold. So I asked, what is the function of a political trial in an autocratic regime? Why do autocrats judicialize punishment when extrajudicial repression is often more efficient and direct? And then finally, how do autocrats ensure that the judiciary actually cooperates with their repressive agenda, right? And there are many scholars in this room today who've done research showing it how we can't assume that judges are going to be complicit, right? Even under highly repressive conditions. So these are the three questions sort of animating the book project. So I'm not going to have a lot of time to go into the theoretical framework, and so it's going to be a very cursory bird's eye view, but just to give you a preview of what I argue. So I develop a theoretical framework, which I refer to as a judicial strategy of repression. I first argue that political trials, these are actually institutionalized processes. It's institutionalizing the process of punishment that helps reinforce the rules of political order, right? Reestablishing the status quo. I argue that this strategy, it's not without costs. right? So in that sense, it's particularly useful to be deployed strategically when autocrats are facing threats to regime cohesion. And again, I'm gonna go over this very quickly, but I'm happy to talk more about this in Q&A. And then the final part of the argument is about how do autocrats ensure that courts actually comply? And so what I examine here is the trade-offs between professionalizing the bench, which is helping to institutionalize the process of punishment. But ironically, the more you professionalize the bench, the less cooperative the judiciary becomes in the autocrats' agenda. And again, I'm just gonna sort of situate like how I'm thinking about this. This is a quote from Judicial, which really helped center me like as I was working on this book project. And it actually has to do with how she defines political trials, because there aren't a lot of, there's not necessarily a lot of scholarly consensus about how do we draw or delineate what is a political trial from a trial that's been politicized. And so I really love this quote from her, which I think is relatively parsimonious. And she says, "What, after all, is a political trial? It's a trial in which the prosecuting party, usually the regime in power, aided by a cooperative judiciary, tries to eliminate its political enemies." Right? This is a definition that I feel like a lot of people can get behind. And she furthermore notes that when we think about political trials in this way, essentially it's a judicial purge, right? It's a purge by judicial means. And so, this is again a quote from Judicial: "A judicial purge amounts to no more than the frosting on the cake of perpetual purges," right? And this is actually a question that I got a lot when I was trying to explain my book project when it was still a work in progress. People were like, "Oh, so you're just looking at judicial purges rather than extrajudicial ones?" I was like, yeah, sure, true. I am looking at judicial purges, but this is like really the sort of the puzzle which like motivated me in the first place. If we assume that it's really just, you know, frosting on the cake of political repression, why do they need the frosting in the first place? Right? If these are autocrats, if they're repressive, if they can do whatever they want, then why don't they just repress? Why do they actually have to go through the motions, the machinations of legitimizing that process through the court, right? Especially when a lot of us take for granted that this is a trumped up treason trial, right? To use a particularly coded term. I just wanted to talk to you a little bit about how much time do I have? A little bit about a little bit about, I talk fast, the data that I use to sort of evaluate this argument. So the Breaking Bad project and the Right Act project is looking at a lot of contemporary trends, especially since the end of the Cold War. I wanted to do a historical project. So all of the data that I collected and that helped me theorize this context was looking at post-colonial history, post-colonial Anglophone Africa. And so I wanted to look at cases where military juntas and civilian one-party regimes were prosecuting people for political crimes. So I focused on incidents of coup plots, right? So these are attempted but failed overthrows of the incumbent regime. I focused on post-independence British African countries. And I also focused on individual coup plotters, right? So individuals who have been named specifically by the regime. And I focus on individuals because these are, you know, by definition, they're contests over power, their struggle over control of the state. They were called coup plots by their contemporaries, right? So again, there's a lot of disagreement about how you should label these conflicts. Are they conspiracies? Were they real plots? We might refer to them as rebellions today. A lot of these plots were actually announced by the regime itself. And this is, you know, potential bias in data collection, because how do we know if this was a real coup plot versus one that was, you know, manufactured by the regime? We see a lot of autocrats, you know, crying wolf, right, saying that there's a plot to oust them. And so with this caveat in mind, regardless of whether these coup plots were real, regardless of whether there were boots on the ground, the political violence that followed was. Right? So even if the pretext was, you know, fake, the repression was still very much real. And I focus on post-independence British Africa, mainly because of the timing of decolonization. I wanted to choose countries that were encountering similar geopolitical constraints. I also wanted to focus on English common law legacies to control for legal regime. There was also still variation in civilian and military rule, which let me sort of leverage variation on my dependent variable. And the countries that I focused on when I was building this data set were Ghana, Kenya, Malawi, Sierra Leone, Tanzania, Uganda, and Zambia. And so I just wanted to show sort of descriptively the state of the data collection on coup plots in sub-Saharan Africa and post-colonial Africa. And so there is existing data, right? So this is actually where I started off. So on the left-hand side, this is the McGowan data set on coup plots, which is it's a really famous data set from the region. And on the right-hand side is the Klein Center. And so one of the things about these data plots is the sparsity, right? And so part of what's challenging about collecting data on coup plots and retrospectively is how do we verify which plots are real and which plots are fake? A lot of this data is collected from secondary sources. So what's helpful is that these scholars have actually printed their rule books, their methodology book, coding books. It's usually they look at the New York Times. The New York Times is like one of the leading sources of our information on historical coups. But as you can see, like look at Malawi, there are like 2 observations across these 2 data sets. They're referring to 2 different plots. So this is a challenge of using off-the-shelf data. So what I did is, I'm running out of time and definitely not going to finish. I apologize in advance. So what I did is I went to shadow archives, primarily in London, so the Kew Gardens, and because a lot of the British government was very meticulous about tracking and stalking their former entities, and they were really concerned about political stability in their former regimes, right? Because if these regimes collapsed, that would look badly on the British government. So basically using these, British intelligence reports, white papers, secret communiques, I was able to triangulate, right, a bunch of individual coup plotters, right? So using historical newspapers, British government archival documents, I was able to collect data on around 2,500 individuals, who around 193 alleged plots from the 7 countries that I listed on the previous slide. And this is to give you sort of an idea of what these documents looked like. Yeah, I'm sorry, I should have brought my glasses. I can't actually read this, but the point being, so the British government was often following these coup plots or conspiracies or whispers of conspiracy in real time. So it was actually like really, it's kind of like reading a political thriller in real time, because you turn a page and like, oh, boots on the ground, page 2, arrests have been made in the Capitol. And this is how I was able to track sort of individuals who were implicated in these conspiracies. Sometimes I would actually get lucky and they would actually just, give me a list of everybody who was arrested. And I wanted to sort of draw attention to this one because this is Raila Odinga, who was arrested in 1982 for his role in the alleged coup. So still politically active today, still not the president. So just as a comparison, right? So on the left-hand side, this is sort of the off-the-shelf data, and using these shadow archive sources, right? I was able to sort of populate more of this map, right? To get more data on some of these individual coup conspiracies. These are histograms of sort of the distribution, how large these plots were across the country. And the main takeaway from this plot is that most of the conspiracies in my data set are relatively small, right? So when the regime, regardless of whether these were real or fake conspiracies, when the regime is accusing you of conspiring to overthrow the president, assassinate the president, usually it's just like 1 to 2 individuals who've been named. So I was interested in comparing judicial to extrajudicial repression, since our default assumption is that repression is extrajudicial. And so when I coded the individuals as being insiders of the regime, right, members of the ruling party or the military, versus members of the opposition, what I found was, and this is not controlling for anything else, there is a pretty stark sorting being done by these political leaders. So if you're a member of the ruling group, if you're a regime insider, you are much more likely to be taken to trial. If you are an outsider, if you're a political nobody, if you're mobilizing in the opposition against the regime, you're much more likely to be dealt with extrajudicially, right? Usually detention without trial, assassination, deportation, exile, what have you. I'm just gonna click ahead. Yeah. So this is, I'm running out of time. This is sort of an outline of the book, the different chapters. So I've shown you a lot of quantitative data, but I think some of the more interesting parts of my book are actually the case study chapters. So talking about like the rituals of political trials, understanding the mechanisms by which political trials help regimes stay in power. These are some of the other chapters of the book. And then another part, which I'm definitely not going to have time to talk about, is understanding how autocrats made courts compliant in post-colonial Anglophone Africa. And one thing I was totally not expecting this across my country cases was how white and expatriate the judiciary continued to be well after independence. So these are all the countries in my data set. The orange bars represent a chief justice who was a white, often white expatriate. The blue bars are indigenous African chief justices. And so there is a lot of variation across the region, but I mean, Kenya, right, had a white expatriate chief justice like through the 1980s, and even after they indigenized the post. Right, so they actually hired a indigenous Kenyan to be the chief justice, and then he was ousted in a very controversial attempted coup. Yeah, so I'm happy to talk more about that during Q&A. I'm definitely gone over. So just to quickly summarize my contributions, I'm trying to broaden understanding of the ways that autocratic power is institutionalized by focusing on the disciplinary institutions of autocracy. I'm trying to rethink repression as both judicial and extrajudicial. And I'm also trying to question the normative assumptions that we often have about the courts, right? And so understanding who justice is actually designed for and who it's designed to serve. So I'll conclude there. Thank you for your time. I really look forward to the feedback.
So many thanks, Lise and Fiona, for excellent presentations. So based on what we have just heard, I'd like to ask the participants to share some of their reflections on what have been presented, and possibly also say something about how some of the findings correspond to your own research on similar processes. So we'll start with the two participants that might say something about how these findings resonate beyond sub-Saharan Africa. So Anastasia, you're doing research on Ukraine. What kind of similarities and differences do you see between the book findings and your own research?
Hello. Oh, hey. Yes. You can hear me. So thank you very much for the invitation to participate. Congratulations to the presenters on reaching such a significant milestone in the evolution of your project. And so, as was mentioned, my research area, my regional research area is on Eastern Europe, in particular Ukraine. And scholarly literature sort of and policy analyses on Ukraine's troubled reform process has delved into sort of circuitous perplexity at the futility of the country's judicial reforms and legacies of Soviet-era economy, corruption, patrimonialism, and oligarchization have all been found to be sort of overdetermined obstacles in this reform process. and the impact of regime type, international influences, and culture on the reform of legal institutions have also been found to have variable outcomes in Ukraine, as well as in other post-Soviet states more broadly. And all of this sort of confirms the broad generalization that the creation of a modern legal order has not been straightforward for post-communist states in democratic transition. Now, despite the troubled trajectory, Russia's escalation of its war in Ukraine this last February has revealed welcome evidence of Ukraine's significant state and institutional capacity. And Ukrainians' demonstrated will to resist the Russian invasion is as much about sustaining its sovereignty and territorial integrity as it is about a commitment to democracy. And sort of conversely, it can be argued that Russian authorities perceive the prospect of democratic consolidation in Ukraine, however convoluted and lengthy the prospective trajectory might be, as a more profound, if not existential threat to the stability of authoritarian rule in Russia and to Russian imperial ambition than the threat, however fanciful, of NATO expansion. And I've been very grateful to, I'm very grateful to be participating in the autocratization and democracy stream in the course this week. And it's certainly given me a very valuable context for looking at these particular dynamics. And I think I'll be speaking now in particular about sort of developments in Ukraine and in Russia instead of sort of Eastern Europe more broadly, and sort of on the impact on the legal system and judicial reform in the country. And so unlike in Russia, the Ukrainian regime has been consistently the electoral regime has been, the elections have been consistently highly competitive since the country gained independence in 1991. And while Russia has implemented laws to restrict foreign funding of civil society, in Ukraine, civil society has really been thriving. International funding has been crucial to civil society, especially monitoring of legal and developments in judicial reform in Ukraine. In fact, I initially started research into judicial politics in Ukraine during my master's around 5 years ago. I took a bit of a detour, got another job, and now as I've pursued PhD study, have returned to this. And I have to say that in 5 years, since 2015, or 7 years, I guess now, oh goodness, since I began the research, there is far more extensive civil society involvement, research in English that is available, and it's really fascinating to see this development. There are even TV shows, especially programmed by civil society, that comment on judicial proceedings and processes. It's called Chest i nechest, honor and dishonor. And so they really do monitor specific proceedings, and they even crown the most dishonorable judge of the particular week to illuminate the kind of dynamics that exist there. So the fact that judicial independence hasn't been consolidated in Ukraine suggests that political competition is not a recipe for independence. And so on the one hand, clearly the Ukrainian judicial independence, I should say. And so clearly the Ukrainian judiciary, so it's not controlled by politicians, or at least then, and if it were, the president sort of would not have gone against it as he did in the constitutional crisis that just preceded the recent reinvasion in February. On the other hand, it shows that political competition has created more space for an assertive court. And if we approach this with some additional nuance, the situation shows that political competition is not going to produce great rule of law everywhere. It's sort of not a magic wand for rule of law. But it's also true that political competition makes it hard to have a fully controlled judiciary. It gives some autonomy and prevents its control. And this is where attention to informal institutions can potentially come in as an explanation. If judges have informal institutions and a professional role conception. If judges perceive the judiciary to be on its own, sort of maximizing out their own rents and making sure to be corrupt and untouched, how do you change their role conception? How do you change the way in which judges are recruited? How do you change expectations among prospective candidates to the judiciary so that they know what they're getting into? And how do you attract people to the judiciary who want to make a difference, who see the law and courts as an opportunity to forward social change? And I'm just at the initial stages of writing a co-authored article on informal judicial institutions in Ukraine, and we're in particular looking at the Constitutional Court. And sort of we're working from the conventional wisdom that informal institutions are harder to change than formal ones, and the assumption that they take longer to change. And if that's the case, then we're sort of interested in looking into how informal institutions around the Constitutional Court have potentially changed in the last 20 years, in what way. And it doesn't matter if the change is for better or for the worse. We're not really looking at progress, but at change. And I think this also is reflective of Lise's discussions in Africa about sort of the status quo change, not necessarily as progress. And so yes, so thank you. I'd be happy to answer further questions later on.
Thank you so much for interesting reflections. We're going to move on to you, Andres. So what about Argentina? How does your research correspond to some of the findings presented by Lise and Fiona?
All right, so thanks of all. Obviously, congratulations to both Fiona and Lise, Leo and Nick for your work, which I think bring interesting thoughts and insights to think about the political and social situation in Africa regarding courts law and democratic erosion. And it's a region that usually, I think it tends to go under the radar of Latin American researchers. I will get back to this in a minute. So two brief comments about your work, if I may, and then some questions that they have made me think about regarding my own work. Fiona's work studies the relation between consolidation of authoritarian terms and weaponization or weaponizing or instrumentalization of courts, as she says. And she argues that contrarily to what some literature says, courts do not necessarily become a refuge for resistance to autocratization. They rather reinforce it and become instrumentalized. And particularly, she points out that challenges posed by insider opponents, and I think this is interesting, require more complex, that is, legal methods of repression. And this gives the idea that courts should be studied as kind of gatekeepers of legitimized domination. I think this is a very interesting thing to think about for further research. And Lise, Leo's, and Nick's work, they study another side of this problem of democratic backsliding by examining how, when, where, and also to what extent institutions and the political order as a whole have taken an authoritarian turn. And there are two ideas I would like to mention about this. First, they explain that democratic erosion in Africa has to be understood from a relational or contextual standpoint. So rather than being independent phenomena, authoritarian turns in Africa and elsewhere in the world have a lot to do. In fact, the rise of authoritarian movements, in France, Brazil, the United States, Spain, and so on, they create a cultural, I could say, or political frame that makes it legitimate in African cases, in the ones that they study, not to give arguments and explanations that justify rulers' actions. I think this is very, very much interesting. And secondly, they argue that collective memory, it's a term I'm using, maybe it's not your term, but I'll frame it as a sociologist, if I might, cannot be ignored in order to understand resistance to the authoritarian turns. In fact, democratic struggles in the 80s and 90s are at the heart of current repertoires of protest and social demands for the restoration of formal, at least formal, legal order. So to sum up, and in relation to Latin American cases, which I know the most, first, courts and law have proven to be quite ambivalent. they never become fully instrumentalized or weaponized. They might become an instrument for repression and domination, of course, but the open texture of law and the open texture of legal systems usually leave at least some space for challenging the political order, for playing by its rules, but also for playing with its rules. So I wonder to what extent do courts and law still represent material but also symbolic opportunities to frame social demands in terms of rights. In this respect, I think Lise's new project is certainly pretty exciting. And secondly, authoritarian terms, whether it's advanced cases such as Brazil, for instance, or potential ones like Argentina or Chile, where we're seeing the rise of new authoritarian leaders. Well, these countries have shown that social adherence to authoritarian values have been growing before the rise of authoritarian leaders themselves. So this brings up the question about social legitimacy of these regimes. And not only how they rule and colonize justice, they don't rely only on repression, but also on at least some partial social consent. So one question or some questions this made me think about is, how are these authoritarian regimes legitimized, we could say, from below, but also what role do courts play in this respect? To what extent is this relation between politics and the judiciary treated and conceived as a problem by the people? Is the redefinition of borders between the political and the judicial a social concern? And also, how strong are democratic values among people? If they have eroded, then why would that be? Could this be analyzed vis-a-vis how substantial democracy came to be during the past decades? What are the variables at stake here? I think your work puts forward the interesting necessity to strengthen a comparative research agenda between Latin America and Africa. I think not a lot has been done in this respect, and that would be very, very much interesting and something that I'm thinking about after listening to your presentations. And mostly, I think Lise and Fiona bring crucial ideas to think about these contemporary challenges. And most importantly, they bring up some excellent and stimulating questions, which are most importantly, I think it's the most difficult thing that social research can bring. So congratulations again.
Great, many thanks. I trust you take note of the questions and we'll get back to them. But first, I'd like to give Matthew the chance to say something about the Kenyan case. So maybe you could share your reflections about how incumbent leaders have sort of sought to contain pressure to democratize through legal institutions in Kenya, but perhaps also say something about international relationships.
So thank you for this opportunity. It's fantastic to be up here and to reflect on this book that's finally coming out, and to have Fiona and the other guests here to actually help us sort of contextualize what's happening. So the Kenyan case, I'll focus on the Kenyan case because that's the contribution that Leo, Arriola, and I made to the book. And what we saw in the course of doing this research is that the incumbents are savvy and strategic. They know which institutions to target and when to target them. So they make concessions, especially when they know their position can actually challenge them at the ballot box. So if we think of 2005, when the opposition was able to quash the incumbent's decision to change the reform process or to control the reform process. And furthermore, when they themselves are able to see that even with the illegitimate use of force following the 2007 elections, that they could not actually just use force to quell the opposition, right? So at these strategic moments, they say, okay, fine, we will open up. Yet this opening up process is not universal. Where the opening up happens matters. Who takes part in these open institutions also matters. And what is actually getting reformed is what matters as well. So for instance, if we're talking about the constitutional reform process, you see it's largely an elite process that has happened. Or when the public is allowed to take part in it, civil society has been crucial. Yet the key parts of the constitution themselves, for instance, presidential power, the executive's power, it might be diluted to have, they might try and make it diluted to have a prime minister or position, but that actually does not happen because the opposition thinks at some point in the future, we ourselves might get into power. So do we want to dilute that as much, right? If we take the legislature, this is another part where the executive is very clever in what they will do. Rather than just thinking, well, we'll just have the elections and be in power, they co-opt the opposition and create these large coalitions that make sure that their power is maintained sufficiently. Yeah. So, oops, sorry, off the pen. So in that way, right, the executive in Kenya has been very clever in sort of co-opting the constitutional making process as much as possible, creating these, for instance, I think you all know about the handshake, where the opposition basically became ineffective a couple of years ago, and now he lost the challenge when he ran for office. This is Raila Odinga I'm talking about. So being strategic in that way. But the part that I think has been most interesting for the executive, and they've not been able to exert as much force and power, is the executive, is the judiciary, right? As Fiona and Lise mentioned, the professionalization of the judiciary sometimes works against them. In this case, the Supreme Court was created. There was a vetting process that was put in place. So rather than in previous cases where if the judiciary made a decision that went against the executive, there'd be punishment, you'd be moved to a different part. Now the judiciary is quite independent and makes decisions that go against the government. Right? So if we think about the 2017 election period where the Supreme Court overturned the election and then there was a rerun election, that was really important. However, the executive, by controlling the purse strings of the judiciary in the legislature, has been able to say that we will not fund it as much. So you saw there was a big dip in how much money was allocated to the judiciary in subsequent years. It refused to, the president refused to, I think, sign off on a large number of justices who had been nominated to the office, right? So in this way, there's a tug of war between the judiciary, which remains really independent, and the executive, which controls the purse strings and its ability to actually function properly, right? But also the nature of the judiciary does affect the sort of endpoint in terms of rights that we see. Right? So for instance, we might think that now the judiciary is much more independent and more amenable to certain types of cases that will promote rights, we should go. But you'll see that the civil society and advocates are cognizant of the ideology within the judiciary. So they will be strategic in how and when and what type of cases they will bring up. So it's not a clear-cut case where simply because independence of the judiciary is happening that all cases could be brought up and will be dealt with fairly, but that everyone is noticing, right? Yes, it is open, but it is limited in its scope and how much you can actually do. On the international side, its dependence on aid has been really interesting, right? It's used its sovereignty claims to say the Western world or these donors need to stay out of our business. So this has happened in following the 2007 post-election violence, when the International Committee said you have to make these reforms for the constitutional reforms. There was a lot of pushback from the incumbents saying, please, it was actually not please, it was basically stay out of our business, right? We will do this at our own time and our own pace and what we want. But also the fact that there's division within the donor community has also helped them quite a lot. China is a big donor now, and so it comes with less pressure to be transparent in what is going on politically, right? And so that encourages corruption to continue compared to the Western donor ideology, which calls for a lot more transparency. So they've been able to use these neocolonial arguments, for instance, if it's about homosexuality, opening it up, and gay rights, to say stay out. But the Chinese option has allowed them to actually be more secretive and less transparent in how they conduct themselves. I think I will stop there and give Kendra an opportunity as well. Thanks.
Thank you so much, Matt. So Kendra, you're an expert on civil society, right? And perhaps you could say something about how governments in several countries have increasingly, used the law to target organizations that mobilize in favor of democratization.
Yeah, thanks. So I will kind of touch off something Matthew said here, which is that incumbents know which institutions to target and when. So for the past 12 years, I've had a research agenda looking at one of the more visible manifestations of whatever you want to call it, democratic backsliding or autocratic status quo. And this is the clampdown on civil society organizations through the use of law. Perhaps you've heard of examples like Russia or Egypt or Ethiopia or Hungary or India, perhaps. So there are a range of countries, democratic and not so democratic, using the law to restrain civil society. And we see that this is it's a new phenomenon. So even though civil society has always been regulated, including during the colonial period, we're seeing new types of legal mechanisms. And these are very targeted. They are specifically designed to restrict access to foreign sourced funding, which a lot of organizations depend on, and also to restrict advocacy activities. And this is very strategic. It's meant to kneecap the political opposition. And so in work I've done with co-authors, for instance, the CMI-UiB at the University of Washington, we have shown that this is very explicitly designed, this legal strategy, to restrain political opposition, because CSOs are often very visible in terms of political opposition, especially at times of political competition, such as elections. And the government uses a lot of the language which Lise brought up in her talk about sovereignty. It is a way to neutralize the external opposition, to curtail the ability to mobilize, and to, as Fiona pointed out, to reinforce the political order. Because CSOs require legal permission to operate, and this is the government's ultimate trump card, and they can show who ultimately is in charge. So we've done some work on implementation. We don't know a lot about how these laws are actually used. Sometimes they seem to be just show, other times they are in fact used to clamp down on opposition. And we do need more research around that. We have done some work on the effects of these laws, which I think is another area where we need to do more work, because there seem to be some pretty concerning effects of these types of legal mechanisms, which includes a reduction in foreign aid. So donors are less willing to send foreign aid to countries that have these restrictive laws. Some work I have going on with a professor at the University of Amsterdam, we have found that there is a reduction in the number of human rights organizations in countries that have these restrictive laws. And also some work that I have going on with Lise Maria Selvik shows that these laws do reduce public support for democratic rights and freedoms. And that's pretty concerning. If the public no longer supports democratic rights and freedoms, we're in trouble. Yeah, I think in the interest of time, I might stop there. One other thing I might mention is that we do see, interestingly, pushback too against these legal strategies, and sometimes very successful. So we see in Kenya and Nigeria that either laws have been thwarted entirely or overturned. And then we actually see, interestingly, the government sometimes stepping back from that legal precipice. In Ethiopia, the government itself overturned its own very restrictive law and has decided that, after all, they don't want to restrict civil society organizations as they did before. So we are seeing the use of civil society and restrictions of civil society as a way to erode democracy and democratic freedoms in Africa and beyond. So I'll stop there, so we have some time for Q&A.
Thank you, Kendra. So before I open for Q&A, I'd like to give Lise and Fiona the chance to sort of comment on some of what have been said. So Andres had some questions, and also, so Lise, Fiona, would you like to respond?
So thank you. First of all, thank you for great comments and great presentation by Fiona. So I think, first of all, I want to say that, so one of the things that, one of the things I'm actually a little bit proud about this book is that I think this book actually manages to bring together a lot of the findings and the works of when you lead big research projects, and there are, Lisa Marie is the project, Matthew, Fiona, Kendra, Siri. I mean, we've been up to 20 people in this project through these years, and all of them are authors in this book. All the country chapters have authors from the countries, and they have junior scholars, senior scholars. It's a really sort of a collective work. And very often that doesn't work. I mean, it becomes a statement like, hey, see how well we've done together, that sort of thing. But so, okay, so I'm going to put my head out there and I'm going to say, this time I actually think we've produced a very coherent book that actually has a very coherent theoretical argument and some really, really solid empirical analysis that actually really sort of point to this. So I thought I wanted to take my time saying that because you guys, you guys are so important parts of this work, and the whole work, all the work that we've been doing in terms of civil society, how the law really affects civil society is based on work coming out of Kendra's original PhD. So, and this is kind of how it builds. And I just also want to say, so your one comment about the collective memory, I think that's super important. And I think that's something that it's incredibly interesting to study across continents. And again, sort of just like showcasing, there is a special issue in Global Policy that Kendra has edited, where we actually took up this point. And there are papers and presentations that some qualitative and some quantitative, but from from Europe, Latin America, African. So, in a sense, I hate that answer, read my book, but, it's not only read my book, read our special issue. I mean, come on. So it's not a great answer, but the question is, it's a very good question, and we need much more research. I want to take one more tiny intervention, since I got this, to highlight Matthew's work and to highlight another really important, which is really both Siri, I think it's Siri and Matthew's maybe greatest insight that we used here, is to see how this legal and international mechanism comes so well together in the politicization of sexual and reproductive rights. What we really see working, and all our country chapters, I think, do really quite a good job of documenting, but also theorizing around, is how African state leaders and autocrats have been a front runner in one particular area. And that is to use to generate national support when you're in trouble, to really politicize LGBT laws and LGBT activity, as framing this as foreign, something Western. So, and so saying, you are not about democracy, you UK government. It's really about the sexual and reproductive rights and LGBTQI rights in particular. And I think I just really want to highlight this, that I think this book does an incredibly, sounds like I'm selling it, but I am selling my co-authors here. I think it does a really good job of documenting this over time and across cases, how this is such a cunning strategy. And it didn't start in Russia, it didn't start in Poland, it actually started with Robert Mugabe. And then, so I think I responded to your question, but I just wanted to broaden it and bring in my co-authors to a greater extent. So thank you. Thank you all for a great job.
Good, Fiona, or would you like to say something?
Okay, I'll keep it quick. So thank you for the really thoughtful feedback. And I totally agree with you that there needs to be more direct comparative work looking at Latin America and Africa. And my very minor contribution to that debate is I have a project that I'm working on with Edgar Franco Vivanco at the University of Michigan, where so he focuses on like on the Mexican case. And so we're gonna look at colonial appeals courts in colonial Mexico versus colonial appeals courts in East Africa. So, but I know that's like a historical contribution to the broader point that you're making about like more contemporary trends, which I think there definitely needs to be more attention paid to.
Great, thank you. So we'll take some questions from the audience. I've already...
Not thanks to me, thanks to Fiona.
I already have Roberto Gargarella on my list.
There's Martha's hand.
Thank you. No, first, congratulations to both projects. That seem fantastic. I haven't seen the books, but I promise I will. No, then one particular question to Fiona, because we got a lot of the empirical data, but we missed the main line of argument. So if you could expand a little bit. And also, I mean, because really I'm curious about that. And just one intuition from what you presented, that you were, I got the impression that you were talking more from the perspective of from above, and also the manipulation of the judiciary by the government, of the manufacturer of the judiciary. But so I was thinking more about how to see that. What happened with the judiciary from the perspective of civil society. And in that sense, I recover the comparison with Latin America. So if we see the fight of the human rights battles, legal battles in Uruguay, even in Argentina, etc., you see that those in governments, those who were at the government, wanted to do this thing, the other thing, to give an amnesty, to pass the... but then they couldn't, because they were total, I mean, always preventing from below, and so they were always challenging from the below, and so it was, in a way, I wouldn't say much less from above than from below, but that was extremely present. So I want to also see, I mean, how important the pressure from below was in the countries you studied to understand what happened with the judiciary. Yes, sir.
Yeah, but I'll give you the chance to respond, and then we'll collect more questions.
Sorry.
Is it actually possible to, like, there is some sort of a AC in here?
A little hot. Yeah, so the theory is, it's very much a theory about the how political trials are used against elites. And partly, I think, partly what was motivating that is because I think there's a way that political scientists think about repression versus institutionalization in autocracies, and repression tends to be something that's done against, you know, everyday people, and then institutionalization, discipline is something that happens within the ruling circle. And so that is very much the framework that I was responding to, and I think that affects the types of political battles that I was looking at in the courts. And because of the nature of the political crimes that I was looking at, so treason, sedition, you know, misprision of treason, these are all political acts which are more likely to be instigated by political notables, right? So not necessarily people at the lowest rung of society. So yeah, that's something that I didn't get a lot of chance to go into much detail in the presentation. But another thing with respect to how the judiciary is sort of like complicit in this, one thing I found that was like really striking in looking at the composition of the judiciary, right? The fact that it was all of these British, often white, expatriate men who were comprising this judicial workforce. At first I thought, oh, this is like a, you know, legacies of colonization, right? The stickiness of colonization. And partly one of the reasons why it seems to be an elite story is because the, you know, indigenous people were not allowed to study the law for most of the colonial era. So it was only the richest, you know, the most politically well-connected who were able to read the law at Lincoln's Inn, right? Because you had to travel abroad. There weren't even local legal training institutes like during the colonial era. But what I discovered in looking at these shadow archives is that a lot of these African presidents, when given the choice between an indigenous African jurist and a white expatriate one, they often opted for the latter because the latter was easier to control. Because if they acted up against the president, they could be, they had their visa revoked, their contract wasn't renewed, and they had a larger pool of candidates to choose from. There was higher turnover among these white expatriates. And the indigenous jurists, because they had to be politically connected in order to study the law in the colonization period, they tend to be like politicians in their own rights. And so they tend to be more willing to stand up and speak up against these, emerging autocrats. So it was just like a weird irony of sort of how this played out. And you even have these records where these British officials are saying, this is a bit awkward for us to continue sending these white expatriates because this looks bad on us, but that's what they want. And that's what they're asking for. So it is a legacy of colonialism, but yes.
So we're on overtime, but we'll do one more question before we end.
Maybe it's just a comment.
No, very quickly, thank you for the panel. And of course, there are many questions, but I will direct one very quick to Fiona. I was listening to your presentation and making an internal dialogue with Anthony Pereira's study on authoritarian legality in Latin America, and he compares Brazil, Chile, and Argentina. And of course, the three were violent dictatorships, but in the end, he concludes that in Brazil, there are more cooperation between the military and the courts, and that ended up also taming violence. In the opposite side was Argentina, where there was less cooperation with the judiciary and more violence. So I was just wondering if you do that relation, and that if that relation makes sense to understand this new wave of autocratization, and if you have that in mind anyhow in your work. Thank you.
Yes, I love that book. Right, that's like one of the only books about political trials in autocratic regimes, and so I was really inspired by that book. I do try to look at rates of conviction across these cases and whether or not and I did find there is a correlation between white judges being more repressive, right, and so more likely to convict on behalf of the autocrat, and indigenous judges were more likely to potentially acquit some of these political criminals. So I think that is a really important source of geographic variation that helps lend credibility to the theory.
Great.
And we're done.
Thank you so much, and thank you for all the excellent contributions from the participants. I'm sure there are plenty of more questions.